So today we are going to prepare for category B, and what we are preparing for is what we call professional conduct and legal writing. Okay, professional conduct and legal writing. We shall start with professional conduct. Do you have someone with the Advocates Act and the Advocates Professional Conduct Regulations? Yes. Do you have anyone with it? Yes.
I only have the Advocates Act, but I don't have the Professional Conducts Act, the registration rather.
Okay. Please, anyone with the regulations?
I have the regulations.
Okay, so let us start with professional conduct. With professional conduct, so the course unit is known as the course unit is known as professional conduct. Okay, is known as professional conduct. Whenever you are reading, the first thing you need to appreciate, what are you dealing with and how do you break it to what you really need. Okay, so if it is called professional conduct, it has two words. It has profession and then conduct. So when you are appreciating that course unit, the first thing you should deal with is who is a profession. So we want to understand who is a profession in the first place. Okay, we want to understand who is a profession in the first place? Do we have anyone with the Partnership Act?
Yes, I have it.
Okay, so let's go to the definition section. You define for us who is a profession in the first place.
The Partnership Act,
Yes.
under Section 1,
Okay.
it defines a professional to mean a person who is a member of a profession regulated by the laws of Uganda.
Okay. It says
A person who is a member of a profession regulated by the laws of Uganda.
Okay. So it says a member of a profession which is regulated by the laws of Uganda. So when you look at the course unit you're dealing with, since it's called a profession, so that means which profession are you dealing with? The profession you are dealing with is the legal profession. So if you are dealing with a legal profession, so ask yourself, which category of people are under the legal profession that we are talking about? Okay, because you need to be a member of a particular sector, okay, which is regulated by the laws of Uganda. And so someone with the Advocates Act, please go and define for us who is an advocate. Who is an advocate?
Okay. An advocate means any person whose name is duly entered upon the roll, and for purposes of section, I think
No,
for the
it's
purpose
okay.
of
It's okay.
section,
That is enough. That's enough.
yeah,
Okay.
I-
It says that is a person whose name is duly entered on the roll of advocates. Okay. So what does this mean? Once you become an advocate, you become a profession. Okay. You become a profession. So if you become a profession because you are an advocate, you subscribe to which institution? The institution is called the Law Council. Okay. Then once you subscribe to that profession, which law governs you? Then you are governed by the Advocates Act. So that means now you fit in the definition of a profession as per the Partnership Act. Because now you are a member of a profession which is regulated. So you've enrolled, you've become an advocate, and being an advocate, you have a law that regulates you here, which is known as the Advocates Act. Okay. So now, once you become an advocate, okay, what type of work do you do? Okay. So you'll be able to appreciate that once one becomes an advocate, you carry out only two types of businesses. That is to say, contentious and non-contentious business. Council, take us to the Advocates Act and define for us contentious and non-contentious business.
Non-contentious business
Okay.
means any business done by an advocate other than the contentious business. I'm not seeing the contentious business here. Okay, contentious business means
Mhm.
any business done by an advocate in any court, civil or military, or relating to proceedings instituted or intended to be instituted in any such court or any statutory tribunal or before any arbitrator or panel of arbitrators.
What does that mean? That an advocate carries out only two types of business. That is the contentious business, which is done in court, and then the non-contentious business that is done outside court. That's the literal meaning. So now, who brings this business? Who brings this business? It is the client. Okay. Who brings the contentious and the non-contentious business? So this business is brought by a client. Counsel, who is a client? Counsel, under the same law, kindly define for us who's a client.
Okay. A client includes any person who, as a principal or on behalf of another, or as a trustee or personal representative, or in any other capacity, has power, express or implied, to retain or employ, and retains or employs, or is about to retain or employ an advocate, and any other person
Okay.
who is or may be liable to pay and to an advocate any costs.
So what does that mean? Okay. That for one to become a client, it does not necessarily mean that it doesn't necessarily mean that you're supposed to be with instructions. Okay. But who amounts to a client? We have that one who has formalized instructions with you, or that one who has not yet formalized instructions with you. Okay. Are we together? So it doesn't necessarily mean that everything should be formal. Okay. So in such circumstances, any person who even contemplates, who thinks of hiring an advocate, whether you or some other advocate, that means is a potential client. Okay. So that, what does that imply? That, okay, that implies that one, we basically have to put into consideration those two things, because a question will come where on the face of it, this person has not formalized instructions. Okay. So you have a client, we shall create what we call client advocate relationship. Client advocate relationship. So ask yourself, how do we create the client advocate relationship? Okay. This relationship is created in two ways. We have a contractual one and the implied one. Okay, we have that one which is implied, okay, from the definition of a client. Okay, and then we have the one which is formalized, okay, where we have written engagement. So ask yourself, how do we formalize instructions? Okay, how do we formalize instructions? So someone with the regulations, take us to regulation 2 of the Advocates Professional Conduct Regulations.
Regulation 2, manner of acting on behalf of clients. No advocate shall act for any person unless he or she has received the instructions from that person or his or her duly authorized agent.
Okay. So when you look at that, the law requires an advocate to have instructions in order to act for and on behalf of that client. Council, take us to section 49 of the Advocates Act still. What we call Champart agreements. Champart agreements. Council with the act, please. Yes. Council with the act, kind of take us to the law.
So I'm afraid I have not addressed my mind to that section. Is it still in the definition section?
No. Section 54 of the Advocates Act.
50?
Okay. Section, look at
Is it-
49, 50, 51.
Oh, okay. All right. Okay. 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 Section 50. Power to make agreements as to remuneration for contentious business.
So remember the types of business we talked about?
Non-contentious and contentious business.
So that means if you are entering into contentious business of going to court, okay, the law allows that we can make an agreement for our remuneration. So remember, an agreement is binding. So we can use that agreement as evidence of existence of our relationship. Council, proceed and read.
Section 50, subsection 1, notwithstanding any rules for the time being in force, an advocate may make an agreement with his or her client as to his or her remuneration in respect of any contentious business done or to be done by him or her, providing that he or she shall be remunerated either by a gross sum or by salary. 2.
Okay. You can first stop there. Okay. So you see, it allows us to enter into Champart agreements, as in how are we going to be paid. So once we enter into Champart agreement, it will be proof of existence of a client-advocate relationship. Then council go to 50, is it 52? Agreements in non-contentious business.
I'm saying 52 says, in circumstances, taxing officer may reduce an amount paid and an agreement. So I'm seeing as if it's a different one.
It's around there. It's around there. Check around 54.
Agreement excludes taxation that is That is 54. Let me see. Let me see. I'm seeing it. Okay, yeah, 55. I'm seeing 55 says miscellaneous provisions as to remuneration for contentious business. And nothing in section 50, 51, 52, 53, or 54 shall give validity to any purchase or acquisition through other means by an advocate of interest or any part of interest of his or her client in any suit or other contentious proceeding. Any agreement by which an advocate retained or employed to prosecute any suit or other contentious proceeding stipulates payment only in the event of success of that suit or proceeding, or any disposition, contract, settlement, conveyance, delivery, dealing, or transfer which is under the law relating to bankruptcy invalid against a trustee or creditor in bankruptcy or composition. I'm seeing any advocate may, with respect of any contentious business to be done by him or her, take security from his or her client for his or her costs to be ascertained by taxation or otherwise. Seeing, I'm not seeing that.
So when you look at that provision and the provision you read first, they allow advocates even to take security from clients. So do you think you can make a mistake, okay, and you go with security when you've not written down anything? Okay, so what does that mean? Any document we write in line with those provisions, okay, it will be an indicator of the client advocate relationship. Okay. So now we presume that we are dealing with our client, we have formalized instructions, everything is okay. So now, how should an advocate conduct him or herself when he is dealing with the client? Okay, the general is an advocate should behave professionally. That's what we call professional conduct. So which law stipulates how an advocate should behave? Then that typically takes us to what we call the advocate's professional conduct regulations. So what is contained in those regulations is basically what we call professional conduct. Okay? And basically professional conduct, this is conduct befitting an advocate. Okay? So if it is conduct befitting an advocate, that's why the law has regulated it. So ask yourself, how should an advocate behave? So when you are dealing with how an advocate should conduct him or herself, you have to do the advocate's professional conduct regulations from regulation 2 up to the last regulation. Why? Whatever is contained therein is a professional conduct between an advocate and the client, and between an advocate and the court. Reason: an advocate is an officer of court. So the questions that they are going to set for you, there will be a problem question, probably that will be number 2. But this problem question, they will give you a passage where an advocate has committed professional misconducts, because we don't have any law that stipulates professional misconducts, but where we have a law that regulates the conduct, if you do anything contrary to that law, it becomes a professional misconduct. So when you fail to conduct yourself as the regulations have provided, you have committed a professional misconduct, and your client will be at liberty to exercise any of the available remedies in East Africa and the entire world. So, do we have any question at that point before we drill into how an advocate should conduct him or herself towards the client and towards court? Are we at the same page? Please confirm before we proceed.
Counsel, all is well, we can proceed.
So I presume that silence amounts to acceptance.
Counsel, we go on. All is well, sir.
Okay, so now let us look at what we call professional conduct. So how should this profession, this professional advocate, how should he behave? Counsel, with the regulations, we are going to read from regulation 2. Let's start with regulation 2. So the first mode of conduct is, Counsel, take us to regulation 2, sub-regulation 1.
Regulation to sub-regulation 1. No advocate shall act for any person unless he or she has received instructions from that person or his or her duly authorized agent.
So the first professional conduct we want to hear from people, that they have formalized instructions. Why? Another Okay, sorry for the interruption. So we've said that one, you are required to formalize instructions. When you read the case of Cavalry Housing Tenants Association versus Cavalry Municipal Council. Court held that
Were banned from baking bread in Poland. That's because Catholic communion wafers are a kind of bread, and it's Catholics that represent the.
Thank you. Court held that an advocate who acts without valid instructions acts for him or herself. So that means it is prudent practice that an advocate formalizes instructions. Council, go to sub-regulation 2.
Sub-regulation 2. An advocate shall not unreasonably delay the carrying out of instructions received from his or her clients, and shall conduct business on behalf of clients with due diligence, including, in particular, the answering of correspondence dealing with the affairs of his or her clients.
So what does that mean? If I have given you instructions to institute a civil suit for me, please don't delay. Don't delay. Institute that suit within the appropriate time. Because if you delay, it is going to inconvenience me. Okay? So you shouldn't delay. So any advocate who does the contrary to that, it is a professional misconduct. Okay? Council, go to regulation 4, leave regulation 3.
Regulation 4. Advocate not to prejudice former client. An advocate shall not accept instructions from any person in respect of a contentious or non-contentious matter if the matter involves a former client and the advocate, as a result of acting for the former client, is aware of any facts which may be prejudicial to the client in that matter.
Okay. So what does that imply? Okay. That remember, we as advocates, we are the masterminds of our formalization of instructions. In the employment world, where people are paid employed, we have a clause which is known as restraint of trade. Okay. Restraint of trade. What amounts to restraint of trade? That after our contract has been brought to an end, I am not supposed to go any further dealing in the same business with some other persons. So, but here under the law, what we basically look at, that if someone was my client, I am not supposed in any way prejudice him or her. Reason, I know most of the facts of my client. Okay, I know what he can do and what he can't do. So as a result of that, you would appreciate that I still owe my client a duty. So if I see in a business which is likely to endanger my client, I am not supposed to engage myself in such business. Reason, it is a professional misconduct. But come to practice, you will appreciate what we are talking about, that it is bogus. Okay? Council, go to regulation 5.
Regulation 5. Duty to appear in court, etc. Every advocate.
Even if you don't read, Council, even if you don't read, it's okay. So when you see, so what happens? I got instructions I have executed them within reasonable time. Okay. The instructions I've gotten are not from the advanced part of my former client. So this implies that I have everything in line. So if I have everything in line, what am I supposed to do? I should appear in court as soon as possible. If I know the matter is at 2, you should get to office at midday. Okay? For easy preparation. So if you come late, it is a professional misconduct. Council, let's go to regulation 6.
Regulation 6. Advocate to be personally responsible for client's work.
Okay, if I have given you instructions, when I come to your chambers, don't send me to the secretary. The law is you should be personally liable. Why do you give me the secretary? Okay. Council, let's go to regulation 7 as well.
Regulation 7. Non-disclosure of client's information.
Non-disclosure of the client's information. You have to read the law regarding non-disclosure. It's called the rule on confidentiality. Under the current legal regime, the law has so much given us liberty. And under this, we have the right to legal representation. Some of the youth are having a lot of liberty. They enter into transactions which are at times illegal. And remember, the end result is getting money. So you are from the backers, they bring you a deal worth billions. But when this deal, you look at it, no gamble anymore. So regardless of the nature and character of the deal, you aren't supposed to disclose. Keep quiet. Okay? Keep quiet. Because the law does not allow you to make disclosure. Okay? So what you do, all you need to do is to keep quiet until, okay, you are given consent. But when you are dealing with that, you should be able to read on the different things. That is to say, the exceptions of the rule of non-disclosure. Under what circumstances will the law allow us to disclose information of our client? Okay. So what are the exceptions? Yes. What are the exceptions, Council? Some of these exceptions are not under the law in the Advocates Act or the regulations, but they are in the practice. Okay. So one, we have self-defense, where the client has sued you in courts of law. You are at liberty to disclose why you are defending yourself. Okay. Then another one, where it is an order of court. Council, what is in order 23 of the civil procedure rules? Yes. Council Mwanga Rafat. Yes.
Agambye
What's under Order 23 of the Civil Procedure Rules? It is
And so I think
garnishi.
attachment of dates.
Aha. But we have two orders and attachment of dates. We have a garnishi nisai and a garnishi absolute. What is the essence of a garnishi nisai?
The garnishi nisai, I think, first of all, its effect acts as a freezing order to the account that is intended to be garnished. But again, it invites the garnishee to show cause why the account shouldn't be what? Garnished.
Aha. I like that, to show cause. So what does that mean? Okay. This implies that where a court issues a garnishi nisai and it is served on you, you should go to court, you disclose, because that is an order of court. Okay. So where that order is issued, you have to disclose the information within your vicinity. So let's go to 8.
8 is advocate to account for money of a client.
Yes. Do you know why we have the client's account and the family's account? Because of accountability of money. Okay. So let's proceed with another regulation.
9 is personal involvement in a client's case.
Yes, that's what we call the principle of recusal. Okay. So now, when you look at those regulations are too many. Okay. But I believe we can read them, okay, at our own pace. But after we've understood what exactly to do. Okay. So whatever is mentioned under those regulations is what we call a professional conduct. So if you carry out anything contrary to those rules, you've committed a professional misconduct. So what is a professional misconduct, Council? Take us to section 2 of the Advocates Act. Section 2 of the Advocates Act.
Section 2 of the Advocates Act
Defines the professional misconduct
to include disgraceful or dishonorable conduct not befitting an advocate.
Okay. Disgraceful, dishonest. You see, imagine failure to appear in court. It will give us credit as lawyers. When you always come late, we shall feel happy. Okay. So are we together there, comrades? Any question before we proceed to the next step? Are we together? Kindly respond so that we go to the next step. Yes.
Yes.
Yes, we are.
Okay. Okay, so now we assume that the advocate has committed a professional misconduct. So what remedies are available to a client where an advocate has committed a professional misconduct? What remedies are available? Now, council, read for us Regulation 3, the first remedy.
Regulation 3 is withdrawal from cases.
Mhm.
An advocate may withdraw from the conduct of a case on behalf of a client where the client withdraws instructions from the advocate. The client instructs the advocate to take an action that may involve the advocate in proceedings for professional misconduct or require him or her to act contrary to his advice to the client. The advocate is duly permitted by the court to withdraw, or the client disregards any agreement or obligation as to the payment of the advocate's fees and disbursements. Then sub-regulation 2.
Mhm.
Whenever an advocate intends to withdraw from the conduct of a case, the advocate shall give his client, the court, and the opposite party sufficient notice of his intention to withdraw, and refund to his or her former client such proportionate professional fees as have not been earned by him in the circumstances of the case. That's regulation 3.
Uh-huh. So now, the challenge is we have what we call withdrawal of instructions and withdrawal from conduct of the client's case. An advocate withdraws from conduct, but in circumstances where it is an advocate who has committed a professional misconduct, what will the client do? That's what we call withdrawal of instructions. Okay. So, because I'm no longer comfortable with this advocate because of what he has done, so I shouldn't continue with him. So what I do, I will abort our arrangement, okay, by canceling out, okay. So which other remedy do we have, cancel, apart from withdrawing instructions? Go to the Advocates Act, you look at functions of the law counsel. So the question is lodging a complaint with law counsel. Yes.
Functions of the law counsel.
Uh-huh.
That is section 3 of the Advocates Act. One shall be to exercise general supervision and control over professional legal education in Uganda without prejudice to the generality of paragraph A, to approve courses of study and provide the conduct of qualifying examinations for the purposes of this act, to advise and make recommendations to the government on matters relating to profession of advocates, to exercise through the medium of disciplinary committee, disciplinary control over advocates and their clerks.
That's what I wanted. So where an advocate commits what we refer to as a professional misconduct, we can proceed and raise a complaint at law council as an administrative mechanism. So once we raise a complaint and it is handled and the matter is brought to an end, that is the end of you. Okay? So now we are done with the coverage. Unless you have questions, I want us to at least read 2 questions of professional conduct. We see how best we can deal with them. Anyone with a question back? Yes? Yes? So now, we don't have the question bank. What I want, because professional conduct has nothing. Just read the rules. Okay? Once you read those rules, or the question is coming with professional misconduct. It wants a remedy of a complaint, okay, or compensation, whatever the case may be, or withdrawal of instructions. All the questions going to do, they rotate around the same thing. So all you need is to read and understand these duties of an advocate and what happens if they are violated. Simple as that. Nothing much.
Council, I have some here. I don't know if I can read.
Okay, you can read. It is okay.
Okay. This one read. This is the professional conduct. Says answer any 2 questions. This one is in respect of question 4. Says Council Kali received instructions from Ewan Sebunya Kavuyo, who came to his chambers in a wheelchair. Sebunya alleges that he was involved in an accident on Entebbe Road where a pickup truck driven by Ewan Sentongo lost a tire. Served off its side. I think swerved off.
First stop there. Is there a client-advocate relationship between the two, or it does not?
Kali received instructions from Ewan Sebunya Kavuyo.
What does that imply?
There are already instructions.
So how should you behave professionally? We proceed.
Swerved off its side of the road, came onto his side and knocked his car. His car overturned as a result, and he sustained severe injuries. He can no longer walk and has now been reduced to using a wheelchair. He wants to sue Sentongo for damages resulting from driving his car negligently and causing him damage. Counsel appreciated the facts, took instructions, conducted the due diligence, set the process in motion. Counsel Kali asked Sebunya to pay instructions fees of Uganda, it paid any money. After scheduling conference, Sebunya calls Counsel Kali aside and discloses to him that he had connived with a medical doctor to falsify the medical report and indicate that he would not walk again, and the doctor had assessed disability at 90%. Indeed, after court that day, counsel had seen Sebunya get up from the wheelchair, walk majestically, and enter his car and drove off. Now, Sebunya hands Uganda shillings 10 million to Counsel Kali and asks Counsel to go and oil the judge's hand so that he can obtain favorable judgment. Counsel Kali is a lawyer who is very particular about his professional duties and believes this is a proper case for which he must withdraw. Question: outline 5 things Counsel Kali should do to discharge his withdrawal obligations fully to the client. 25 marks. That was the question.
So when you are reading that passage, do you see any professional misconduct?
I've seen oiling the judge's hand.
Yes. From that question, have we committed any professional misconduct?
I think Counsel, when I don't know if I heard properly, he says he came with a wheelchair, but when he went out, that means he was lying, because he went out and then he got into his car. Was he really injured, or he really wanted to get something from the other person? Because as far as professional conduct is concerned, you're an advocate, you owe a duty to court.
So you see, that's how all questions are. Just understand, okay? These things, all questions, that's how they're going to be coming. Nothing is going to change, okay? Any other question?
Question 5, it says Chibwetere, an advocate of some years standing, during the lunch hours, assaulted his colleague and opponent Mwerinde in the courtroom with a knife. A pistol shot is also said to have been fired by Chibwetere at the time of incident. After investigation, Chibwetere was prosecuted for the offenses. He was convicted, but before he was taken to serve sentence, he was involved in some fraudulent acts designed to frustrate his imprisonment. The fraud was discovered and he was subsequently imprisoned. Question: in light of your knowledge of the duties of an advocate, very briefly describe the conduct of Chibwetere, the advocate. 25 marks. Have you had the question, Counsel?
Kindly rephrase.
That in light of your knowledge of the duties of an advocate, very briefly describe the conduct of Chibwetere, the advocate. The facts are that Chibwetere, an advocate of some years standing, during the lunch hours, assaulted his colleague and opponent Mwerinde in the courtroom with a knife. A pistol shot is also said to have been fired by Chibwetere at the time of incident. After investigation, Chibwetere was prosecuted for the offenses. He was convicted, but before he was taken to serve sentence, he was involved in some fraudulent acts designed to frustrate his imprisonment. The fraud was discovered and he was subsequently imprisoned. So they are saying that in light of your knowledge of duties of an advocate, briefly describe the conduct of Chibwetere. The brief facts we have heard are that Chibwetere, one, assaulted his opponent, Mwerinde, in court. And he was investigated, he was prosecuted, and before he was taken to prison to serve his sentence, it was discovered that he involved himself in fraudulent acts. So those are the brief facts. So I think the question is looking for the duties of an advocate towards fellow advocate. I think that is what I would pick from these facts. One, a duty towards the fellow advocate. Two, duty towards the profession.
Mika,
Yes, please.
there is also duty to court because the incident happened in court. I also need to respect court, the premises.
Okay. So there are three duties. Yes, please.
So once you fail to execute your duties, what next? So
I think the next is that
yes.
I think it is
Are these things,
how much are we
things
supposed to write? Because like the question is 25 marks. Like I was asking for guidance because like how much are you supposed to write? The question is 25 marks. Are we just going to go straight to duties and what? And stop at that. How? Kindly guide us on how we are supposed to do what?
Okay.
Tackle the question and for us to raise the 25 marks. So just get on duties in 5 and then you stop at that.
In every question, make sure you define who is an advocate. In every question, make sure you talk about creation of an advocate-client relationship. Okay. Then you talk about what exactly the question will be wanting. Because the fact is, getting the K25.
Can I run through other questions?
Council, what's
Council?
wrong? It's okay. It's okay. Let's do one man with C.
Is this one of Council Alphonse SQ of MS Lugambo and Company Advocates represents
Yeah, you can
Chagulanyi.
read. You read.
Okay. Council Alphonse SQ of ESQ of MS Lugamba and Company Advocates represents Chagulanyi, a building contractor who happens to be a plaintiff in a suit for breach of contract to build a house. Chagulanyi also has pending before the zoning commission a petition to rezone the property he owns. Before the zoning commission, Chagulanyi is represented by Mutamiv ESQ Kasoro Dickens, who owns property adjoining that of Chagulanyi, has asked Council Alphonse ESQ to represent him in opposing the action of Chagulanyi before
Council, first stop there. Identify a duty which is there. Which duty?
I have seen a duty. There is conflict of interest.
That's one. Is Chagulanyi a former client in any matter or not?
Represents Chagulanyi.
Is Chagulanyi a former client of council in any matter or not?
No.
Okay, let's go on.
So it says Chagulanyi before the zoning commission of Kasoro Dickens is fully aware that Alphonse ESQ represents Chagulanyi in the breach of contract matter. A. Would you consider it proper for Alphonse to represent Kasoro Dickens?
So now you see, you define an advocate, you show that an advocate has a duty, okay? And if this Alfonso proceeds to represent Chagulanyi in this matter, he will be in a breach of his duty. Which duty is that? Conflict of interest, not to prejudice former clients as well. So the question is only testing one duty.
B. Highlight 3 reasons to support your answer.
The reasons we've given them. So 1 requires you to take a stand. Okay? Simple as that.
There is this one in section B that the chairperson of the Law Council has requested you to represent the body. The Law Council as a guest speaker. The BACOS students of LDC on the topic professional ethics in contemporary Uganda, the challenges and the best practices. Outline the salient points of your presentation.
Hey, that question is simple. They want you to discuss how an advocate should conduct him or herself in the contemporary Uganda, where corruption is too high, ethical considerations. So literally they want you to discuss the entire advocate's professional conduct regulations. All those regulations, you have to talk about them, because that is how an advocate should behave in the contemporary Uganda.
Now this one calls you to almost discuss the entire advocate, the entire Advocates Act and its regulations, professional and
only they want only the regulations. Council, the act is not inclusive.
Okay.
So is professional conduct hard?
I think it's doable.
Okay. So that we can handle. Okay. So any other question?
As in the question
No,
bank?
about what we've dealt with.
No. Maybe if the colleagues have.
Okay. Anyone with any question? Any question? Hajat Afwa, any question?
No, Council.
Okay, so you see that question is doable. So what we're supposed to do right now, let's keep practicing. Get the question bank. Any question, go through and see how best you can deal with it. Okay. So we are going to be having these sessions probably every evening in Pola and Pola. Okay. So that we can make it a point. So for today, let us end here. So let's mark that at least professional conduct has been dealt with. So our next session is going to be of legal writing. So we shall be having these sessions until the day we go for those exams, inshallah. But please, members, don't forget to practice accounting and taxation. Okay? Yes. So let me wish you guys the best. Okay? We are going to shine. Okay? I believe orals will be better. Okay? And we shall make it. I have you guys in prayers. And we serve a very big God who will never let us down. We pray that the Holy Spirit guides us through these trying moments. Okay? And we are blessed. And I believe we are. Assalamu alaikum wa rahmatullahi wa barakatuh.